on the cloud. Okay, so today we're going to start a new topic. And the next third of the semester is going to be all about this topic. And we're going to get into a lot of details about this topic. This is the wonderful world of contracts. And contracts exist in every facet of interaction that you have had up until this point in life. You have entered into a contract, definitely, without a doubt. There are different types of contracts. So we're going to talk about, verbal contracts, oral contracts versus written contracts. We're going to talk about enforceable contracts, void contracts, how to get out of a contract, how to make sure that your contract is solid if you don't want the other party to get out of it. So there's a lot of different types of contracts, and we're going to go over that. In a very simple terms, what can you tell me a contract is? Anyone?
An agreement between two people, two or more people.
Yeah, it's an agreement between two people. Omar, it does not have to be written, and you'll see why later, right? But I love contracts in writing. I'm a big proponent of contracts in writing, no matter how small of something you're agreeing to. And we'll get into that in a little bit later. But a contract is essentially an agreement between two parties. When we get down to the nitty-gritty of it, there's actually a little bit you can dissect that statement more, and that's what lawyers do. They dissect things. Before we get into the types of contracts and what's binding and what's not binding, we're going to go over some preliminary information. So this is now a listening part, right? Not a writing yet. But a lot of times, contracts were not really set in the law. There was not like a criminal law where you have a statute written out and you have those elements. Contract development happened really, kind of like a case by case. And so they started writing things down. That way, if you have one result in one area, you would want to have a similar result if you had that similar fact pattern. The problem with contracts is you could have a disagreement between, you and another person over a contract, and you could have one outcome in one area. And because it wasn't codified, it wasn't written down, you could have somebody with a very similar fact pattern, in a different state that has a very different outcome. So there was really nothing for people to use as a guide to have an understanding of, hey, if I breach this contract, what's going to happen to me? Or did I in fact breach this? Or did I have every right to, back out of this contract because of the certain, situation? Every case is different, right? Because fact patterns change. And that's something that should ring a bell to you. We've talked about fact patterns, since the beginning of the semester. You could have one small fact change that could have a different outcome for a case. Why? Because the fact pattern has changed. It gives you a little something extra to think about. There's two different types of contracts. And you're going to, again, this is a listening still. There's commercial contracts, which are contracts that are done between businesses. And then there are consumer contracts, where it's a business between a consumer. When you're dealing with two businesses that are entering into a contract with one another, it's a lot more stricter. Why? Because these business owners get into contracts on a regular basis. So sometimes there's a higher burden or a higher standard for them to invalidate a contract because they should have known better. But when you have a consumer entering into a contract with a business, generally speaking, the consumer is not doing this on a regular basis. And so sometimes courts will favor a consumer if there's a misunderstanding. Why? Because they don't get into contract on a regular basis. In 2012, there was something called the restatement of consumer contracts, because it was, kind of finally decided, hey, we gotta start kind of putting things down in writing. That way consumers have an idea of referencing things. So the UCC, the Uniform Commercial Code, Article 2 now governs the sale of goods. And it's usually the sale of personal goods, personal items. And when we talk about the sale of personal goods, personal property, you should remember what personal property is. It's the sale of stuff, right? One item being sold from one person to the other. When we talk about personal property, there's laws that apply. Real property is different, right? Real property is land, houses, and things like that. That's different. But the Uniform Commercial Code really deals with the sale of personal property. So you kind of want to keep that in mind. When we talk about goods, if I use the term goods, it means tangible personal property. Again, the words tangible and personal property should ring a bell to you because we just talked about it not that long ago. So when we talk about a contract for the sale of a phone, what's the good here? The goods are that phone that we're actually contracting over. And when we talk about, we're going to get into this later, but sometimes a personal good that somebody's purchasing may have an element of, you know, installation, let's say. So then it's like, well, what's governing? Is it the UCC Article 2, which governs the sale of goods? Or is it now something else, another aspect that we have to look at? And the example I could give you is, let's say you buy 100 tiles from a tile store, and your contractor installs those tiles. Those tiles after installation are now breaking. Who is at fault? Is this a contract dispute between you and the tile company? Is it between you and the installer? Who's at fault? What governs? What kind of law governs? And those are the things that we're going to talk about over the next couple of weeks when we talk about these things. When we also talk about a contract, a good contract, right? A contract that's enforceable is binding, right? When you enter into a contract with somebody else, it means you can enforce your rights against that individual, and that individual can enforce their rights against you. So you always want to read a contract. You have to look at the fine print. We talked a little bit about, when we talked about rental properties before, and when you're renting a piece of, you know, a unit and a lease, let's say, you have to read the lease, right? Because what we were saying before is, it depends, you know, if your microwave breaks, does your landlord have to actually fix it? Well, it depends on what's written in the lease. And a lease is a specific type of contract, but that's over, you know, real property, but it's still generally a contract. This is something that's going to blow your mind, right? Now listen to this phrase. I want you to write this down because this is fun. All contracts are promises, but not all promises are contracts. And you'll see why. Again, I'm going to say it again. All contracts are promises, but not all promises are contracts. Okay? And you'll see why when we talk about the definitions of contracts. Okay, when we talk about contracts, there are 4 basic requirements. In order to have a valid contract, these elements must exist. So again, when we talked about, remember criminal law, when we talked about intellectual property, we talk about elements of a particular, you know, definition, right? It's a definition of things. So contracts also have 4 basic requirements. This is something you must know for the exam, for the second exam that's later on in a couple of weeks, right? We're going to talk about these. Every chapter that is coming up over the next, you know, syllabus or whatever, they talk about in detail about these 4 items, but I want you to write them down now because I need you to know what they are. So the 4 basic elements, which are the requirements of any contract, you must have mutual assent, ASSENT. I'm going to define each one later. I just want to get the 4 down first. Mutual assent. Number 2 is consideration. Number 2, consideration. Number 3 is my favorite, legality of the object. Number 3 is legality of the object. And number 4 is capacity, specifically mental capacity. So those 4, again, those 4 elements are mutual assent, consideration, legality of the object, and capacity. I'm going to now explain them quickly to you, but again, we have specific chapters dedicated to each of these. So we're going to talk about it in detail a little bit more. So when we talk about mutual assent as the first element, it means that the parties that are entering into a contract must indicate indicate to each other, whether it's through words or through conduct, that they intend to enter into a contract with one another, that this isn't like a surprise of some sort. So what does that mean? Either by words or conduct, they are agreeing to enter into a contract with one another, that they both have this kind of understanding of what they're about to do. Okay, so mutual assent, one of the other ways that we show mutual assent is by something called offer and acceptance. Offer and acceptance. So if you have offer and acceptance, that's the element of mutual assent, because both people are essentially agreeing to what they're about to enter into. Number 2, consideration. Each side, so there's in a contract, let's say there's only 2 parties to this. Each side has to have a legal benefit or a detriment. There has to be some kind of exchange. So the best way I can explain consideration is if I enter into an agreement to sell my phone to somebody, I'm selling my phone and I'm getting something in return. I'm losing my phone. My legal detriment is I'm losing my phone, but my benefit, my legal benefit is I'm getting money or something else of equal value, something else that I really want. Okay. So the items that are being exchanged don't necessarily need to have the same value because it depends on what somebody is looking for. To give you a stupid example, but that's something that's going to actually like stick with you. Last night, no, it was Saturday night. Saturday night, my mom was kind enough and gracious enough to keep my kids overnight. Thank you. So I came home and I was like super happy, super excited, right? Because I was going to come home. It was going to be quiet. I was going to be able to watch TV, watch what I want to watch. I put out a little fruit platter, fruit and cheese. And what I wanted to do was sit on the couch and watch TV. What I couldn't find was the remote control. And in my head, I was like, I would give anything right now to find this stupid remote control. If you were telling me, give me $100 for that remote control right now, I would have given it because I just wanted the remote control so I could watch what I want. I eventually found the remote control. But the remote control's value is not $100. But to me, at that particular moment, that's what I would have given to get that remote control. So when we talk about consideration, don't think of it as an equal value, $100 worth of stuff for $100 worth of stuff. It's just an exchange of items, a legal detriment and a benefit. One person gains, one person loses something, but it's when you flip it, the other person gains and the same person loses. You're gaining and losing on each end for that same interaction. Okay? Y'all with me so far? Nobody's raising. Okay, thank you. The next item is legality of the object. Legality is whatever you're contracting over must be legal in nature. Very simple. Love that one, right? If you decide, I don't know what the prevalent drug of choice right now amongst young people, but let's say you are buying, you are entering into a contract to buy, I don't know what's out there nowadays. I'm going to just go with weed because, I think that's still around. If you were contracting with somebody to buy a pound of weed for $100 and you go and you make that exchange with that individual, and then you go home and then you open your weed, but then you find out it's not weed, it's actually, rosemary or parsley or something like that. Are you going to be able to go to court and sue this individual for selling you parsley instead of weed?
No.
No, not right now. Martin, you said yes. Why is that?
Because I kind of related to the search warrant of the police. I related to something like that. That's why I said yes.
Okay. Well, because these contracts are between individuals, private citizens. And so when you're contracting over an illegal object, you cannot then take them to court because right now still weed is illegal. So you can't go to court and you cannot tell a judge, We contracted, we had mutual assent, we had consideration. We have these elements of a contract. I paid him $100 for 1 pound of weed, not a pound, not a pound of parsley, because the item that you're contracting over is not legal. You should not be contracting over the purchase of an illegal substance or an illegal activity. So the same thing would be if you contracted over illegal gambling, or if you hired a hitman to kill somebody for you and then they don't do the job but they took your money. You can't go to the police and say, arrest this person, there's a breach of contract here, judge, breach of contract, I want to enforce my legal rights and remedies, I want to get my deposit back on that contract to kill. Why? Because you're not supposed to enter into that to begin with, right? It's my favorite one. I love this one, legality of object. So whatever you're contracting over must be legal in nature. The last one is capacity. Capacity is also super fun. I think that's my second favorite. Capacity is, you need to be able to enter into a contract with somebody that has the requisite mental capacity. If you think back to when we were talking about wills, I had mentioned that you need very little mental capacity to have a will. And if you were going to do a trust, it's actually a higher burden of understanding in a trust than it is in a will, because a trust is considered a contract. So if you are entering into a contract with somebody who does not have the requisite mental capacity, then it could be avoidable contract, meaning it might be found that it's not valid. Why? Because the mental capacity was not there. The same goes true for a minor. A minor, somebody under the age of 18 who enters into a contract, can actually get out of it. Why? Because they are legally not allowed to enter into a contract up until that they reach that age of 18. And again, we're going to talk about that a little bit later. Y'all with me so far? I'm not seeing any chatty questions. What if you don't know if it's illegal? Okay, and then parent consent. So for Omar, what if you don't know? So ignorance of the law. Okay, so ignorance of the law is not an excuse, but I like your clarification now. Stolen car, but you didn't know it was stolen. When you're purchasing a car, you're supposed to get the title. So if you're purchasing the car and you were given a title and it was a fraudulent document and you were duped, you are something called a bona fide purchaser. So you would not incur any liability, but you're now going to be entered into a dispute of some sort. You're going to be brought in as a third party when the original owner sues the person who defrauded them and probably sues you to try to get their item back. You're going to be like, but I actually paid good money and I got the title. So in that situation, I don't know whether or not, you're not going to go to jail for that, but you might not be able to keep the item that you purchased, because in essence, it was a stolen item. So if it's found out and somebody wants it back, they could probably get it back because they have the original title, the original ownership aspect of it.
Would you get your money back that you paid for the car?
So it depends on who the fraudulent person is. You should be able to get your money back if it's a civil case, but if it's a criminal case, then that person goes to jail and you're not going to get anything back. So you want to do a civil and criminal. You want to do like both legal actions in order to try to get your money back. Somebody else had something else. Oh, that was it. Parents' consent. If you have a parent that consents to you entering into a contract, like a guardian of your property that allows you to enter into these types of contracts, then that's fine. That's fine. Okay, I'm gonna now move on to Steinberg versus. I have a note here. Sometimes a contract has to be in writing in order to be enforceable. However, there are contracts that are orally done and they are valid. So if you've ever watched Judge Judy or any of those, daytime, nighttime shows of, the judgeships and courts and things of that sort, sometimes a lot of people come in and there's a dispute, and Judge Judy, whoever the judge is, they'll talk about, what actually transpired, who said what, and is it considered a verbal contract or not. So legally, if the item you're contracting over is $500 or more, it has to be in writing. If it's under $500, then you can have it as a verbal contract, and it could be found to be enforceable depending on the situation and circumstances surrounding that agreement. I, as always, very big in favor of written contracts. Why do you think that is? We'll get into that right now. Why do you think I think that written contracts are better than, oral contracts?
Because if they try to back out the deal, you can take them to court and show them your contract as evidence.
Yeah, evidence. It is a file. Exactly. You have something you can refer to, because whenever you enter into, look, I don't have the best memory in the world, right? I have to write emails, post-its, send text messages to myself, set alarms. Sometimes it might not even be nefarious in nature, but people forget. And so why leave it up to chance when you can just memorialize what your agreement is while it's fresh in your mind? You go back 2 weeks later and, hey, don't you remember we talked about X, Y, and Z? No, I don't remember. And it's not a lie. You could just not remember. So when you reduce things to writing, you're reducing the chance of error and the chances of somebody, just forgetting what was discussed. So you have a point of reference for both of you. So
and
and everything's
also
clear.
like deny it. And
Yeah,
say,
absolutely. So yeah, and people could deny it, right? People could say, no, oh, that wasn't me, that's not blah blah blah. But it's like, no, but wait, we just talked about it, and you signed off, and that's agreement. That's what you have more of a case when it's in writing.
I have a question about that. So
Sure.
if they didn't sign it, right, but they were present when it was made.
No, you got to sign it. Then if it's not executed, if it's not assigned, then it's not a contract. It's got to be
What
signed.
if it was written by them? Like it was written, but it wasn't signed by either party, but it was just written by them.
So then you're going to go back to like proving that they did in fact write it. What if they say I didn't write that?
I don't know. Aren't there like machines that you can use to validate handwriting?
So now if you're going to go to a handwriting expert to try to make a case for whether or not that person's writing, so it must be something that you're contracting over of value. So at that point, why wasn't it done the right way? Meaning, didn't you have an attorney draft this document that was signed and reviewed by both parties, right? You also want to kind of take into consideration now real life application. If you're contracting with somebody over something that's a couple of $100, $1,000, you're probably not going to go to an attorney. Why? Because the attorney is going to cost you more just for their time, right? But if I'm a fan, even if you want to build a case for the what if, right? What if this contract falls through? What if this agreement falls through? So if they put something in writing, great. And if you have to take them to court, then you make your case and you try to have witnesses and, somebody that saw them or somebody that can identify their writing. One of the things I like to do, and I think I had spoken to you guys about this before, is let's say you had some kind of verbal agreement. You want to reduce it to writing by saying what? By sending an email as a follow-up from your email account to theirs. Whether or not that's going to, go with the rules of evidence followed by a court, it's different. And again, it depends on how big the case is and what the dispute is over. Is it $1 million case or is it a couple of $100 case? So, but when you put things in writing, I guess even if somebody doesn't sign it, you can use that towards your case in front of Judge Judy or in front of small claims court. But you'd have to be able to prove that, because if the other person says that's not my writing, then it's your word against that person's word. And it goes back again to credibility and the circumstances surrounding it. And so also, just as an FYI, when you sign something, you should get it notarized. That way, there's no question as to whether or not that's that person's signature or whether it was fraudulent, because now you're bringing a third party like a notary public whose sole job is to confirm that whoever's signing that document is that indeed is that person. Okay, so now, okay, so with that being said, let's move on to Steinberg versus Chicago Medical School. Who would like to tell me about that case? Pretty simple case. Go ahead.
So basically, Steinberg applied to a medical school as a first-year student, and he paid the $15 application fee. He ended up being rejected by the medical school, so he filed a lawsuit against the school because he believed the school didn't evaluate his application. based off the criteria that was given to him. So the court believed that the school entered into a contract by accepting his fee and should have reviewed his application correctly.
What was the problem? Because do you remember, not that they didn't evaluate his application, but there was a little bit more.
I believe they rejected him for circumstances that were not in the contract.
Correct. They actually posted what the criteria that they were looking for, right? Grades, blah, 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 right? They had all this stuff written down. But then when they were deciding who was going to be admitted into their school, they were looking at other criteria like pedigree, family history, who had attended that school, and that was not advertised. So he won this case. Why? Because once they accepted his filing fee, his application fee, they had entered into a contract. They had put it out there and said, hey, students, we are going to be looking at the following A, B, C, D, and E to determine whether or not you get into our school. That's the only criteria they should have applied. If they were going to be applying other criteria like family, pedigree, who you know that actually went into the school, that should have also been advertised, because then a knowing consumer could decide on their own whether or not they want to apply to this case, the school, based on this criteria or not. Make sense?
Yep.
Excellent. Thank you. And thank you for acknowledging my questions. It's greatly appreciated. Okay. The next thing we're going to talk about is, let me just actually look at my syllabus real quick. Today we're going to go to 9, 10, 11. Okay, 9, 10, 11. Okay, cool. We're still on 9, FYI. Okay. When we talk about contracts, and this is something I want you to now kind of pay attention to, there are different ways to explain or compare. There are different ways to compare contracts, okay? There are express contract and implied contracts. So that's one classification, right? Is this an express or is this an implied contract? So that's a classification, express or implied. I want you to know what that is. These next, there's the textbook gives you 4 different classifications. I want you to know the first 3. So those are the ones I'm going to go over. Express or implied contract is 1. That's 1. Express or implied contract is 1. What does that mean? An express contract is where both sides clearly manifest, show their intent, whether it is in writing or whether it's verbally or whether it's through conduct, that they are intending to enter into this contract. It is clear. These people signed a contract together. They both said to one another, we want to enter into a contract with one another. It is clear. An implied contract is, there's nothing in writing, but the conduct suggests that they are entering into a contract with one another. So, you know, you are at a restaurant or something, you order food at a restaurant. The implied connotation is you're going to now be paying for that food, because don't forget, let's say like an action such as just as simple as you going to a restaurant to eat. Maybe that's not so simple anymore nowadays, but if they bring you food, the implication is you're going to pay for that food, right? That's a contract. You are getting a service, you're getting food, and you're going to pay for it. So you did not verbally say, I will now pay you for the meal you're going to be, you know, placing in front of me. But it's implied that once you eat, once they bring you out the food, you're going to actually pay for it. Okay, so that's express or implied contracts. The second classification is bilateral or unilateral. Again, I want you to know this. This is the same thing. I usually test a little bit on this. A bilateral contract is where both parties are making promises to one another for the actions they're going to take. Whereas a unilateral contract, only one side is making a promise which is contingent upon the action of somebody else. And I'm going to give you an example. If I were to say, if you were to say to me, or I was to say to you, if you promise to mow my lawn, my front yard, I promise to pay you $10. So if you promise to pay to mow my lawn, do my grass, I will, if you promise to mow my lawn, I promise to pay you. All we did was promise to one another of what we're going to do. Different than if I was to say, if you mow my lawn, I will pay you $10. How is it different? I don't know whether or not you're going to mow the lawn. I don't know. You didn't make a promise to indicate that you were in fact going to take this particular action. All we said was, if you do it, if you take a particular action, then I'm going to pay you. You're not obligated to. Whereas in the first example, if you promise to do it, I promise to pay you. So all I need is your verbal agreement saying, I'm going to do this for you. And I'll say, okay, I promise I'm going to pay you money. It's like a word for a word rather than contingent upon the action. It's contingent on the, not just the act, but the promise to act itself. So let's say we were actually in the classroom and I was to say, I'll pay anybody, if somebody could drive me home, I'll pay you the, $20 to take me home. If somebody was to say, I promise I'll take you home, and then I'll say, okay, I promise I'll pay you. So it's a promise for a promise. It's a bilateral. Whereas I'll pay you $20 if you take me home. Whoever takes me home, I'm going to pay $20 to. Right? It's not about the promise. It's about the actual act. Does that make sense?
Yes.
Thank you.
Yeah,
Thank you.
it makes
Thank you.
sense, but you said bilateral, and what's the other name?
Unilateral.
Unilateral, okay.
Yeah. So bilateral for two, unilateral for one. Now, the next one, the next classification, it's actually 4 different things, and that's valid, void, voidable, or unenforceable. So that's another way to classify contracts. Valid, void, voidable, or unenforceable. So what do these mean? Plain English. A valid contract, it's a good contract. We met the elements, those 4 elements that we spoke about earlier. All 4 elements are there, no problems. A void contract, void, V-O-I-D, it is not a contract at all. It's not a contract. There's no contract here. So you can't even have a void contract because it's not even there's no legal effect whatsoever. It's not a contract. So the example I give for a void contract is make an agreement with, or thinking you got into a contract with somebody who is mentally or intellectually disabled because they don't have the mental capacity to enter into a contract. You will not have mutual assent. You will not have consideration if it's somebody that's legally adjudicated as not being able to make decisions for themselves. So how are you going to have an agreement of the mind? How are you going to have offer and acceptance? How are you going to have the capacity aspect if it's somebody that does not have that mental capacity? So a void contract is not a contract at all. A voidable contract is a contract that can be voided by what I like to call the innocent party. So if you entered into a contract with somebody who was intoxicated at the time of agreeing to this verbal agreement or this written agreement, they were actually intoxicated at that time, so they did not have their mental, faculties present. Once they come to within a reasonable period of time, that person who was intoxicated has the option of voiding that contract because they did not have the requisite mental ability to make that particular decision at that particular time. However, you can't wait a month and then be like, oh, wait, you know what? At the time that we entered into this contract, I wasn't all with it. So I'd like to void it now. That's not how it works. It has to be done within a reasonable period of time. So you know, the next morning, oh, wait, what did I just sign? What did I agree to last night? Okay, now we got to try to void it. Okay. So that's a voidable contract. An unenforceable contract is the law. You entered into a contract. You both signed it. Yes, Martin.
Professor, what happens if you don't remember making the contract?
It's going to be, you can try to get out of it as soon as you practically can. So that's when fact patterns come in. If you have absolutely no recollection, if you were drugged and you have absolutely no, like, don't know what happened, and then, you know, a couple of weeks later, you finally saw this contract and you're like, I don't remember this at all, then you're going to try to get out of it because it has to be within a reasonable period of time based on the situation and the circumstances.
Thank you.
You're welcome. So a unenforceable contract is a contract where the law does not provide a remedy. So like not complying with the statute of frauds or getting into a verbal, so like getting into a verbal agreement for the sale of a house. You have the meeting of the minds, you have the mutual consent, you have the consideration, you have the legality, and you have the capacity. So it's a valid contract, right? Like, hey, let's just shake hands and decide that I'm going to buy your house for $1 million, right? But it's actually not enforceable. Why? Because the law says if you're going to buy a piece of property, that has to be in writing. So an unenforceable contract is a contract where there's no remedy in the law itself. Okay? Great. Okay.
Yeah.
Thank you. The next theory I want you to know, this is now second to last thing for this chapter. It's a wonderful theory called promissory estoppel, and we're going to have a case that highlights what this concept is. So promissory estoppel is a legal doctrine, which is like a legal theory, which says, you know what, sometimes you might not have a contract, but you should enforce the agreement, because if you don't enforce the agreement and there was justifiable reliance on that agreement, then it wouldn't be fair. And justice would require you to enforce this agreement that doesn't actually exist. So promissory estoppel is a theory that goes against everything I explained to you about valid, void, voidable, unenforceable, because there's no contract there at all. But the court and the law still says if they choose to enforce this promissory estoppel theory, there's no contract, but we're still going to enforce this agreement that you have, because if we don't do that, it would not be fair. And the perfect case to explain that theory, to kind of highlight it, is skeba versus cash. Who wants to tell us about that?
I can.
Go ahead, Sada.
Seda.
Sorry.
Okay, so Kosh was the business owner. He hired Skeba. Skeba was later on throughout the years promoted to VP, I believe. He got an opportunity to venture off to a different company, but Kosh begged him to stay. Skeba said, well, here's my terms. Kosh agreed to his terms to, if the company was sold, give him $250,000. But when the company was sold, he changed his, what did he do? Oh, his lawyers drafted a different contract and then gave him, I don't know, something else that he didn't really agree to.
Was there a contract? Was there an actual contract when Skeba decided to stay?
I think it was more of an oral one, like verbally done.
More of an agreement,
Right.
yeah.
Yeah. So it was a verbal agreement between them. Skeba kept asking for something in writing. He never got it. He turned down the other opportunity with the other company that had offered him a job because he relied on Cash's promise. Hey, I want you to stay. You're my top salesperson. When this company is sold, I'm going to give you $250,000. Company gets sold. So Skeba's like, where's my money? And then Cash is like, I don't know what you're talking about. So then Skeba takes him to court. And what does the court say? The court uses the theory of promissory estoppel to actually grant this person his money. Why? because this person detrimentally relied on this agreement, verbal agreement that he had with this person. He was able to show and prove whatever ways. He didn't have anything in writing, but he was able to prove his case, preponderance of the evidence, to show that his version of the facts is more likely correct, that he relied on this promise. He relied on Cash saying, I'm going to give you $250,000 if we sell the company. Don't go to the other company. You're my top salesperson, blah, blah, blah. He relied on all that. He turned down the other opportunity. So if the court did not grant him this win, it would be not fair. It would essentially not be fair. It wouldn't be right, because then Cash basically would have screwed Skeba, and that's not right. Make sense?
Yep.
Thank you. Excellent. Okay, so that concludes chapter 9. We're going to move on to chapter 10. Chapter 10 now goes into detail of mutual assent, which is that first element that we talked about as one of the requirements for a contract. When we talk about mutual assent, what is mutual assent? All it is an agreement between the parties. And it is the core of a contract. It's the essence of a contract. It's what the two sides are agreeing to. Mutual assent is both sides coming to terms with and agreeing to enter into this relationship with one another. When we talk about a contractual agreement, it's for either a promise where somebody's going to do something or not going to do something, right? Both sides have to benefit, right? You're not going to get into an agreement with somebody if there's not something for you. If I'm entering into an agreement to buy a phone, I'm getting a phone out of it. If I'm getting into an agreement with somebody, with my neighbor, to build a fence, I get a fence, or he or she gets a fence, and we can be better neighbors. If I'm entering into an agreement not to do something, it's because I'm agreeing not to do this particular act, because if I had continued to do it, perhaps then I would have gone to jail or whatever the situation is, right? So it's an agreement between two sides to do something, and you have to be doing it without anybody forcing you. It's got to be, you want to do this, you want to enter into this relationship, you want to enter into this agreement. So how do you indicate that? Well, you either put it into writing, or you simply say, I want to get into an agreement with you. Let's get into this contract. Let's do business together. What do you think of you do X, Y, and Z? You supply these items and I will go ahead and sell them, right? We're entering into a contract, a business relationship with one another. The law is now listening, not writing. The law doesn't really care what you contract over or what the terms are specifically, because both sides entering into an agreement with one another should be kind of mindful, or like you're agreeing to what is best for you. So like, I like to collect coins. Perhaps I'm willing to pay $100 for the buffalo nickel from 1895, but you may think that's crazy. That's okay. It doesn't matter what you think, because that's something I'm willing to contract over and pay for because it's something that I want. Just like, maybe kids, very, very young kids are, not them, maybe it's their parents, are willing to pay, $10, $15 for something called a Pop-It, which is the, newest fate. I don't even know if it's still current, but like, it's a piece of plastic. It's still current?
Yeah, they're obsessed with it.
Okay. Who's obsessed? You or your young
No,
people?
no, the little children.
Little children, yes, because I have them and mine are obsessed with it. And I'm like, it's a piece of plastic. It's kind of like bubble wrap. Yeah, like bubble wrap.
Yeah, it's just plastic bubble wrap.
Plastic bubble wrap. Yeah, and you just pop it. Like, I don't understand it. I think a couple of years ago, fidget spinners were something that was also, right? People were paying for the, whatever, how much for these, whatever these things were, right? So it doesn't matter what you're willing to pay for a particular item. The value doesn't matter as long as you're willing to pay for that value. The book goes into like offeror, offeree, who's the offeror, who's the offeree. It's fine. Don't worry about it. when we talk about an offer and acceptance, so all an offer is a proposal to indicate your willingness to enter into this agreement. It's kind of like how do I say this? Like before you play basketball, or or what is it? Like tailgating, I think it's called, before the actual game, right? So that's how you think of an offer and acceptance, right? It's the pregame, right? It's before the actual essence of the game itself. So that's what an offer and acceptance is. You're kind of feeling things out. What are you going to agree to? What are you not going to agree to? What are the limits? What are we going to do? Is there a time of the essence clause? And kind of like feeling things out to see whether or not somebody's going to get into an agreement with you. So when we talk about an offer itself, there are 3 essential elements of an offer. It has to be communicated. This is a write it down moment. So essential elements of an offer, right? And then the offer and acceptance is that's part of the mutual assent thing of a contract. So essential elements of an offer is communicated to the offeree. There has to be communication. There has to be an intent to enter into the contract. And there has to be sufficiently definite and certain. There has to be finite limits to it. Remember we were talking about, proposals, and I was like, it's better to tell somebody that you will love them for a month than to say I will love you forever. That's actually legitimately an element, and now you're making it into a contract. I promise I will like you for the next month. Past that, I cannot guarantee. So you're giving them a finite moment of time. You're telling them how much you're going to like them for.
I'm sorry, Professor, can you repeat yourself?
Sure. So when we talk about an offer, there are 3 essential elements, right, to an actual offer. It has to be communicated. There has to be an intent to enter into a contract, and it has to be definite and certain. Definite and certain. So when you tell somebody, so I was likening it to like, oh, it's better to tell somebody I'm going to like you for the next month than to tell them I will like you forever. If you were to bring it to a business standpoint, I promise I will sell 10 of these widgets. Better to say that's an actual offer, rather than say, I will do my best and I will sell as many as I can. That's not definite and certain. That's you having wishful manifestations of, hope and glory. That's not good. That's not good to have an actual offer. That would make it not a valid offer because it's not definite and it's not certain. So in an offer and an acceptance kind of thing, you must have finite idea. There has to be set goals. There has to be set numbers, set time frame in order for it to be a valid offer. We're going to go back to the first element, communication. So there has to be communication. You can't think in your head what you're going to offer to somebody, but then not offer it, because then how are they going to know? So the example I usually use is, I'm going to, let's say I have my own business and I have my assistant, and I want to offer my assistant a promotion, and I'm going to give her a bonus. So I write this letter, and I write, dear, let's say my assistant's name is Christopher. That's my kid's name. Dear Christopher, you have been an exemplary employee over the past 2 years. I'd like to recognize your hard work and dedication to this company by giving you a $25,000 bonus, one-time bonus, and increasing your salary from $1,000 a week to $1,500 a week. This will be effective immediately. I leave the letter. This is Friday afternoon, right? Friday after work. So Friday, I leave the letter on my desk. I close my door. I go. Christopher's still working in the office because Christopher always works late. Christopher goes into my office. He was going to leave some files, and he sees this letter addressed to him. He's like, $25,000, $1,500 now, my weekly blah, 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 instead of my $1,000. You know what Christopher does over the weekend? He goes on a shopping spree. He goes and he decides, with $25,000 bonus, I'll finally be able to get that Tesla I always wanted. So he goes to the dealer and he puts an offer on a Tesla. He wants to, buy one because now he'll be able to finally afford it. Now, Monday morning, we come into work. Christopher's all happy and cheery and blah, blah, blah. I go into my office. Christopher says, good morning. I say, what's so good about it? We just lost our biggest client over the weekend. I go to my desk. I see the letter that I had written Christopher and I rip it up. Can Christopher enforce that $25,000 bonus and that increase in monthly, weekly wages that I was about to give him?
No,
Why?
because you made it and you didn't introduce it to him. He
It
introduced
was
himself.
never communicated to him. It was never given it to him. We didn't have that mutual assent. We didn't have that communication. I didn't actually give it to him. So it was all in my brain, essentially. So if there was no communication, I did not physically mail it to him. I did not email it to him. I did not hand it to him. He cannot try to enforce that. So Christopher is, SOL out of that. Okay. So that's the communication. The second aspect, again, manifest an intent to enter into a contract. Both, again, it just goes to both sides having an understanding, whether it's verbal, email exchange, or whatever, about what the relationship they're about to embark on. When we talk about intent also, it has to kind of be reasonable. If somebody says, oh, would you be willing to buy my car for, what year are we in now? 2021. Would you be willing to buy my 2021 Tesla or BMW for $100? And you say, yeah, sure. Is it reasonable that anybody's going to sell their car for $100 in 2021? No, it's a joke. So you can't then take that and say, oh, we had a verbal agreement. You were going to sell it to me for $100. No, it's not reasonable. So it's whatever, verbal exchange happens or it's in writing, it's got to actually make sense. It's got to be reasonable, and not like a joke. So that's that. When you have preliminary negotiations with somebody, that's preliminary negotiation. It might not be considered actual offer and acceptance, and because it's still kind of you trying to get into the specifics of your actual deal. So it's not really a valid agreement if you're just in that preliminary exchange to determine whether or not a particular deal is going to work out for you. So it's kind of like also like advertising. Advertisings are not considered offer and acceptance, and they're not binding because offers are considered, they're advertising. They don't contain a promise. And there's a lot of, missing terms that would be necessary if you were to actually have a valid contract. So Black Friday's upon us, right? That's like next month. You know how all the stores will advertise, I don't know, like a TV that's, I don't know, what's a 84-inch TV for $100, at Target, Walmart, or whatever. What does the fine print say, young people? What does the fine print say? If you go there and you wait and you go into that store, are you going to get that 84-inch TV for $100?
No, it's not guaranteed.
Yeah, why not? What does a small print usually have?
You monthly payments, something like that.
Right? No, what else does it usually say? If you were the second or third person online and you go in there, first come, first serve. And while supplies last. While supplies last. So you could be camped out in front of Best Buy. You could be the fourth person online, but they only had 3 TVs and the people in front of you took those TVs. So you're not going to get anything. So it's going to say, while supplies last, first come, first serve, things of that sort. Who wants to tell us about Lefkowitz versus Great Minneapolis Surplus Store? I don't usually test on this case, but if you want to tell us about it, it's fine. I'm not crazy about this one. Anyone?
I know it.
Does anyone else besides Ms. Hardeen want to tell us about anything in this case? Not that I don't want to hear your voice, but anybody else? We have how many students here tonight? Out of the 40 students that are here, anybody else want to say anything? All right, Ms. Harding, go ahead.
Okay. So Lefkowitz, he read a newspaper article that was talking about fur coats and first come, first served. It would be $1 each, even though they were $100. So he arrived at the store, but the store said, no, we're only selling to women. And then the following week, he went back to the store after another article, and they refused to sell to him. And that's where I get confused. I don't understand what happened.
So then they said to him, well, you should have known the house rules that, you know, we're not going to sell to you because it's only for women. So he had an understanding by the second sale that it's not for him. Even though I don't remember if that was actually explicitly written down, but the reason they did not sell it to him was because the advertising was clear, definitive. There was nothing left in negotiation, but their advertising didn't actually say that it was only for women. And so when he went there, he was supposed to get those items because there was nothing that said, it's like, hey, you go there, you're supposed to get it regardless of whether or not you're a man or a woman. Again, I'm not particularly crazy about this case. I don't usually test on it, but it was about knowing the house rule or not, whether or not there was any room for miscommunication or misinterpretation of it. So that's that. When we talk about certain contracts, that definitiveness aspect to it is important because that's what doesn't leave like wiggle room. So if you order something from Amazon and you order a blue handkerchief, do they have the option to just send you whatever it is that they want? No, you ordered X, Y, and Z. You're expecting X, Y, and Z. It's definitive. It's fundamental. It's absolute. That's what a contract is. It's the absolute nature. So you know what to expect because you bargained for a specific particular item. Sometimes, however, depending on the relationship between the parties, you may have an open term and that would be okay. It would still be a valid contract. So if you are a seafood restaurant and you count on fishermen and fisherwomen to get fish from the ocean and then you buy it from them, you may not be able, they're not going to be able to tell you, I will be able to give you, 56 fish, tilapia fish, right? It might just be per season, or I will get you whatever I can. Maybe that's the agreement that you have with them. Sometimes the terms between, like, there's something called an output contract or a requirement contract, where it's an agreement between two parties, or one party will say, like, I'm the fisherman, I will get you all the fish that I can fish and I will give them to you. You're going to be my direct person that I give it to. And sometimes it's that works for that particular type of relationship, rather than you being so specific and saying, I'm going to be able to collect 60 pounds of fish from you on a weekly basis. That might not be feasible, but to have a general open nature might actually be better for that relationship, especially when it's a business to business relationship rather than a business to consumer relationship. So when we talk about an output contract is an agreement of a buyer to purchase a seller's entire output for a particular period of time, whereas a requirement contract is an agreement for the seller to supply a buyer with all his requirements for certain goods for a particular period of time. So there's no specific amount actually recorded. It's just that generality. I will give you everything I make. I'll be your direct supplier for that particular period of time. How long do durations of offers last? So let's say I make you an offer. Have anybody here ever watched Shark Tank?
Briefly.
Okay. And yeah, a couple of people. Okay. So how like somebody, sometimes if they have a good idea or a good product, the sharks will make an offer, right? My mom loves that show also, Victoria, and that's how I kind of started learning about, Shark Tank. So if you have a wonderful idea, the sharks will make you an offer. What are your options? If you're that person now, sometimes you can accept the offer. Sometimes you want, well, I want to see what the other, out of respect, I want to see what the other sharks have to say. It's not really, you just want to see if you can get a better deal, right? So an offer is that, like that, again, pre-gaming to kind of like get into the offer and acceptance so you can kind of work out those terms. So how long is an offer good for? And that's this next section of your chapter. An offer is good for, it could be once it's accepted, then we're done, right? So it could be either by acceptance, write this down. So I want you to write down these like 8 items. Acceptance is the first one because we're talking about the duration of an offer. So once you accept it, offer is done, finished. It's finished. Lapse of time, meaning a particular time now, it's finished. So I'm going to give you this offer for the next 5 minutes. If you don't tell me what your answer is, the offer is poof, it's gone. Revocation is the next one. The offer can be revoked, so it's good until revocation. Number 3, rejection. That will terminate an offer, rejection. Next one, counter offer. Counter offer. The next one is death. If somebody dies who made the offer, it's no longer on the table. Next one is destruction of the subject matter. Whatever it is that you're contracting over, if it's no longer there, if it's destroyed, so that offer is presumed to have been revoked. And then the last one is subsequent illegality. So whatever you're contracting over, after you've contracted over, now it's become illegal. So now that offer is gone. Okay, so that's duration of offers. Next case is a case I usually test on, so I do want you to know this one. This is Sherrod versus Kidd, K-I-D-D. Who wants to tell us about that? Sherrod versus Kidd.
So I know like half the case, but I just don't remember what the actual outcome of the case was.
You know what? We'll take it. That's fine. Otherwise, I was going to say I'm going to test on it and I'm not going to review it because everybody has to read. Go ahead.
So Red was purchased a house from King.
No.
What case are we on?
Sherrod versus Kidd, not.
I don't think this is on the syllabus.
I don't have that.
Let me see. Hold on.
The next case I have from the syllabus is Nabberger versus Nagberger.
Oh, I don't tell you guys about Sherrod versus Kidd. I don't even put it on the syllabus anymore. Oh, sad. I'm going to tell you about this case then. I guess I'm not testing on it. I guess I stopped testing on it. It's wonderful. Okay, so you know what? The one you're talking about is that sale of the property, right? That's a fun case. I want you to tell me about that one. I love that case. I do test on that one, actually. So let me tell you guys about Sherrod versus Kidd. So Sherrod versus Kidd, there was a lawsuit between them. An offer was made to settle the case for $32,000. So the side that was like, so I made an offer, all right, $32,000, we sell the case. The other side doesn't respond, doesn't say anything. They go to arbitration, and then the arbitrator awards $25,000. So then they were like, oh, no, we'll take that $32,000. Too late, an arbitrator made an award. You can't say then that you want to take the higher offer because although you did not answer, your lack of answer and you going to arbitration is now a revocation, an automatic revocation of that offer. So you can't kind of wait and see how it goes and then say, oh, no, I'll take that higher number. That's not how it works. So that's what Sherrod versus Kidd is about. Okay, revocation, blah, 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 rejection, counter offer. Does anybody have any specific questions about those like 7 or 8 elements on, accepting or rejecting an offer? I could go into it in detail. Otherwise, I'm going to move on to the next chapter. Anybody?
I actually want to ask about the duration of an offer, about
Sure.
under death or incompetency. Can you explain an instance where incompetency comes into play?
Sure. So if somebody got hit by a car and then they're in a coma. So at the time they entered into a contract with you, they had their full capabilities and mental, faculties there. Then they're in a coma, or they got sick, or they're in a hospital and they're no longer able to communicate. So now that offer that was made, it's really presumed to have been revoked, because now that person is no longer able to make any mental decisions. Does that make sense, Marn?
Yes, thank
Yes.
you.
Okay, you're welcome. Okay, so now we're going to move on to chapter 11, which is the last chapter for the evening. Oh yeah, we have Neugbauer, Reed versus King. These are really fun cases. Okay, let me see here. They are on the syllabus. That's good. Okay, so you've entered into a contract, right? But sometimes there are situations where the contract that you've signed or that the other person has entered into makes it not valid. And that's what chapter 11 is about. So if somebody has forced you to enter into a contract, to sign a particular contract, it's not valid. Remember when we talked about wills and undue influence, or fraud and things of that sort? It's the same idea. If somebody forced you, put a gun to your head and told you to sign that contract, it's not a valid contract. If they, manipulated you to enter into an agreement, that's not a valid contract. So improper threats can not only be physical, but they could also be like financial. I'm going to destroy you financially if you don't sign this contract. Well, that's a threat. You should be entering into an agreement because you want to, not because somebody's forcing you to. Undue influence. It's when somebody is in that position of power and they force you to do something. Again, not valid. And the perfect case for that is Neugbauer versus Neugbauer. So who wants to tell us about Neugbauer versus Neugbauer? Love that case. Love that case. I always test on this one. And it's on a syllabus, so I guess I still do. Neugbauer. Who wants to tell us about Neugbauer? So there's only two cases left for tonight: Neugbauer and Reed versus King. I'll even take, I think Alessandra, you said Reed versus King. Why don't you tell us about some of it? Okay, tell me what you know.
So I know Reed purchased the house from King, and King never disclosed that there was a woman and 4 children murdered in the house 10 years earlier.
Yeah.
Reed ended up learning about the murder from a neighbor and found out that King actually asked the neighbor not to inform him about the murder, since he knew it would affect the market value of the home. And I know that Reed obviously sued King for this because of recession and damages, but I got a little bit confused on like the actual rest of it, because it was like, I know like the judgment was a little confusing, because then they ended up like taking one side and then it was reversed and they went to charge.
You did good with the facts. The bottom line with this case is you had the original owner of the house tell the neighbor not to disclose a particular fact. Don't say anything about the murder. So he was actively withholding information. So then the purchaser paid more money than he would have had he known about the murders, right? So that's considered fraud. And so the purchaser wanted to get the difference in money. How much if he had known that there was a family, that was murdered there, he would have paid $10,000. Instead, he paid $15,000. So he wanted that difference in money. And that's really what it comes down to. When we engage in fraud, meaning actively withholding certain information, that was his mistake. If he had said nothing, or he did not tell the neighbor not to withhold information, and then the purchaser found out later on his own that there was a family that was murdered there, well, then that purchaser would not have any recourse. Why? Because you should have done your due diligence and looked up the house to see if there was anything, weird or scary about it. Like, if you didn't do that, that's on you. But because the original owner withheld information, actively told the neighbor not to say anything, That's where the problem was, and that's why he lost his case and he had to pay the difference in the value of the house. The guy, I guess, didn't have a problem that there was a murder there of 4 or 5 people, but that he overpaid. And so that this was how he was able to get that money back. Okay. So that is Reed versus King. I do usually test on that case also. Now I'm going to go back to Neugbauer versus Neugbauer, which is a case I also test on. So who would like to tell us about that? Okay, so I'm not going to discuss the case. It's your responsibility to know what that is, and it's going to be on your, next exam. Again, I reiterate that I do not give you assignments. You don't have any pop quizzes. The only thing that you have to do in this class is read to prepare for class. So with that being said, I'm going to move on to the next topic. If you had a house, let's say, and it had termites, if you actively try to conceal that fact, there's fraud there, right? It's misrepresentation. If you had a leak and you paint over it so the leak doesn't show, that's actively misrepresenting. It's better to just leave the leak there so the owner knows. And again, when a person is buying a house, they're supposed to do their homework. They're supposed to get that inspection. But you don't want to take any active step to misrepresent the condition of a particular business or home or anything like that, because then it's fraud and misrepresentation, which you can, be surcharged for. Let me see here. Sometimes, however, mistakes happen. And so if you make an innocent mistake, you're not going to have that fraud, but the person who was duped innocently will have the ability to void that contract because they're that innocent party. The last thing I want you to know for this chapter is assumption of risk. Assumption of risk is a topic you heard before. When we talk about it, when it comes to contracts, is if let's say you buy a particular item from a garage sale, you're buying that item as is, right? You're not getting any kind of guarantees or warranties on that particular item. So you could buy it and it could not work, or you could buy it and then be on the Antique Roadshow because it's worth a lot of money, right? So assumption of risk when it comes to making purchases like that is you buy it, you're taking a shot. It could be either be very valuable or it could be a piece of junk. There's no, yeah, exactly. What you see is what you get. Like that's it. So there's really but you're not going to be able to go back to the owner and be like, oh, this didn't work. You're buying it. It's a final sale. It is what it is. And sometimes when you go to a store and you buy like a floor model of a particular item, it's as it is. It's a final sale. Don't come back to us and say that this was broken. You should have seen it kind of before you purchased it. So when we talk about assumption of risk when it comes to purchases or contracts, that's what that means. Okay, so that's the last thing I want you to know for this evening. Does anybody have any questions on any of the items that we covered this evening? Let me stop recording.